asexual. And then your lordship says plus plus. The actual correct thing is, so well, this plus plus is a whole shade, a spectrum of different hues and colors. Now, clearly, if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lordship doesn't have a balance tomorrow a new person coming here and saying this. So the correct formulation would be two consenting adults. I'm only giving a summary. Two consenting adults along the bodily gender and sex. There are two words here. Of course, on the confinement, it is with great respect, the better profitable way of doing it. There are very valuable arguments by the Hindu Marriage Act batch or even by other personal laws. Both of us in the two lead matters are not arguing that. We are only in SMA. So, a way to start would be to limit it there. I entirely bow down to what is falling for my lords. But on the canvas, just 3 or 4 minutes, there are two crucial words here: marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage, largely, my learned friend is covered. Whereas there is two categories of consequences. These are consequential issues she is raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, in any case, now you can have a live-in. You need not even call it marriage. It is because of the consequential benefits. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now, there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly, we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all, giving it up or lessening it. But your lordships in this, the crucial word which fell from the Chief Justice is incremental. I always believe that, your lordships in such matters is like a rubber band. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break, because that slowly movements is on the societal view of the rubber band. Now, adoption, according to me, is crucial. Is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to, in fact, itemize. But your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell. That is point one. Point two of the canvas is even more important. The point arises from not having to come to your lordships every day. That's why I said the word is actually more appropriate. I've looked into this, some literature, same person. Now, your lordship has got, one is heterosexual marriage. Lordship will call it this side. One is man-man or woman-woman, which we call homosexual or lesbian on the other side. Now, there are two actually parameters of differentiation. One is sex-based, which must include between the man and woman sex. There is also a whole range of combination of persons with special biological features. It's not only man, it's not only woman. The second category is gender. That is the masculine, feminine. So a male body can be imbued and overshadowed by completely female psychological instincts, and vice versa. So therefore, once your lordship holds today, assume, as a matter of argument, that your lordship were to hold that same-sex marriage is valid. Same sex in the sense of man-man, woman-woman. It is not intended that persons who are in this, what is known as the whole range of shades, the complete spectrum. What your lordship, we tend to say LGBTQ. I looked it up, it is L, lesbian, G, gay, B, bisexual, T, transgender, Q queer, I intersex. And then your lordship says A, asexual. And then your lordship says plus plus. The actual correct thing is, so well, this plus plus is a whole shade, a spectrum of different hues and colors. Now, clearly, if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lordship doesn't have a tomorrow a new person coming here and saying this. So the correct formulation would be two consenting adults. I'm only giving a summary. Two consenting adults along the bodily gender and sex spectrum. Either you define by gender or by sex spectrum. This is the other facet. Now, all of this can be profitably started with SMA, because your lordship is making a start. Were your lordship to leave the rest of it explicitly open, or your lordship may have a deferment and have it considered separately, it's entire your lordship discretion. They have also valuable points. I have not only the Hindu Marriage Act category, other people also. Hindu Marriage Act category is there also. Secondly, let us be very clear. I heard with some alarm, my learned friend's opening intervention. Nobody is arguing at the moment, nobody, I will not say, at least the two of us, or the three of us, are not arguing personal laws at all.
We are also not.
We are not.
Number three, we are, what is the meaning of this repeated thing about state intervention? Your lordship, for the first batch, is interpreting this way or that way, whether SMA, and our arguments, that is my arguments, are in two parts. One is these fourfold parameters of discrimination, which is the most important, 15, 14. Second is freedom of expression. The very interesting facet of freedom of expression, the lordship has said, is symbolic in a community sense, not only individual. Third is dignity, 21 and other things. Fourth is how to remedy it. And the second part of the submissions is the entire notice objections regime of the SMA. That part would have to be held unconstitutional. The first part is interpretive. If your lordship is with us on that, the second part would have to be unconstitutional.
The notice issue is even in a heterosexual marriage, because you are saying that even in a heterosexual marriage, the fact that you have to give a notice and have people object to whether there should be a marriage or not is unconstitutional.
The funny part is, and this is just an aside, that the object, howsoever noble, of having this section 5 to 10 regime is being proved by statistics on the ground to have the exact opposite effect. Exact opposite. Your lordship invites opprobrium, oppression, physicality, violence, elimination, extermination. And I'm asking myself one question. Your lordship has conditions of marriage in all, even Parsis, Christians, Hindu Marriage Act, other acts. Conditions of marriage are there, something or the other is there. If you give an affidavit saying I'm satisfying the conditions, and your lordship subsequently files the affidavit to be false, or any spouse finds it, or even a third party finds it, can be struck down. It's void or voidable, it's struck down all the time. You don't need to have a notice period in advance after the conditions. This is peculiar to only the SMA. Your lordship is not allowing those conditions to be violated by the non-following of objections. It's a absurd situation. Now, that being the situation. Yes. This intervention about state objections.
No, I'm saying therefore, you say you don't want to touch personal laws, correct? And we've also put to you don't touch personal law.
I have not touched.
Then the argument is in a very limited compass or
focused.
Then confined is, can we in the Special Marriage Act read a person instead of the definition of a woman or man?
That's all.
That's all.
And leave everything else for some good time in the future.
My lord, just one aspect.
And no state intervention inhibits your lordship.
May I then proceed?
My lord, just one aspect.
I think we'll now get back to Mr. Rodgi. So we'll get back to Mr. Rodgi.
My lord,
now clarified. 1 second, just 1 second. 1 second. We have, I think, all of us on the bench have now clarified the area, or you may call it the limited area, or the area that we are going to explore in this case. Let's hear Mr. Rodgi on that, because I think
my lord, just on the ambit, my lord.